Okay, so we've gotten that far. Anything else? No.
Not on these.
Okay, now, let me just introduce myself. My name's John Hurley. I'm your judge this morning. We are in first appearance court. Today is the day the court determines whether or not there is probable cause for your arrest. We're not here for trial. We're not here to determine whether you're guilty or not guilty. That is not for today. I'm telling you that because when you get called forward, you do not need to tell us about your case. You don't need to explain yourself, defend yourself. You don't need to make any excuses. Those things are not for today. Save those for your attorney in a private meeting. Understand that everything today is being recorded. You have the right to remain silent. You should utilize that right at all times. But if you give up the right to remain silent today, whatever you say can and will be used against you. Also, if you have a private attorney, when you're called up, let me know who that is. We'll contact your attorney and let them know that you're in court. Deputy, may I help you with something?
I'm here for defendant Filmore.
Marcel Filmore, Your Honor. It's a perfection.
Marcel Filmore.
Yes, Your Honor. I've provided, Your Honor, and defense supplement report, but I also, this is Detective Toledo, and I asked Detective Toledo to appear just to clarify any issues or facts that the court may
Okay, so will you raise your right
concerned
hand?
about.
Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
I do.
Okay, put your hand out. Tell us your name.
Detective Marcos Ruiz Toledo.
Okay, and you're employed by
The Broward Sheriff's Office.
Sheriff's Office, and you have an opportunity to investigate Mr. Marcel Filmore regarding the robbery, the burglary, and possession of a weapon or ammunition by convicted felon.
Yes, Your Honor.
Okay. The issue here was the issue.
Your Honor, well, two things. One, there was an issue with identification. Two, I think
Okay.
in order for this, Your Honor, I'm going to be seeking to foreclose on the burglary with battery, and I believe more facts should be brought to the court's attention to reach that level. Also, I want to clarify for the court right now, on count one, we're seeking probable cause for attempted robbery with the weapon. In this instance, just to clarify before we get into the alleged facts, because I know there was mention of a firearm, Your Honor, for the purposes of this charge, the state is alleging that the rock and the manner it was used was a weapon.
Okay, let me just review this real
Sure.
quickly.
What county?
Can you get him to tell me what happened, man? Hey! Clarify what you're talking about. Yeah.
Okay, so here's the issue that you say that it was an attempted robbery. Okay, so I see that part,
Yes, Your Honor.
probable cause. The burglary with the assault or battery, we have a young man allegedly breaking the window of a vehicle after he allegedly says, give me all of your, I'm not going to say it, but give me all your belongings. And then he allegedly picks up a rock, breaks a window, and says he reaches in the vehicle. But after that, the court doesn't see anyone in fear. The court doesn't see anyone who's been battered. Would you agree up to that point from what we see here? That's missing.
No, Your Honor, that's why I've asked Detective Toledo to be
But
present.
on the document we have, that's not there.
It would appear, Your Honor, and that's why, after speaking with Detective Toledo yesterday, I asked him to come in.
Okay, so the detective's under oath. Would you like to, if you want
Yes.
to go ahead and ask questions, go ahead.
Detective Toledo, you had an opportunity to investigate this case.
Yes, sir.
And you took a sworn statement from the alleged victim, Thomas White.
Yes, sir.
Could you please tell the court, based on your investigation and the sworn statement you took from Thomas White, starting from the beginning, what the what allegations were made against Mr. Filmore regarding this incident.
Okay, Mr. Filmore ran up to the driver's side door of Mr. White's vehicle, asked him to give him all his stuff. At that time, he was producing what Mr. White believed to be a weapon from behind his lower back.
Now, what time, this was, it looks like 13:47, correct?
Yes,
So
sir.
that's 1:45 in civilian time, right?
Yes, sir.
1:47, I'm sorry. Okay, so go ahead and,
So, simultaneously, the victim, Mr. White, started to open his door in order to strike the suspect, Mr. Filmore. At that same time, Mr. Filmore produced a large rock with his right hand, which he smashed through the window of Mr. White's vehicle, maintaining grip on the rock. Mr. White put up his hand. The rock actually struck Mr. White's hand, causing small lacerations and the broken glass cutting the top of his forehead.
the broken glass cut the occupant of the vehicle's forehead.
Yes, sir.
Okay.
At which time
See that cut?
I saw small lacerations, but it was already cleaned up. The blood was already cleaned up by rescue.
Okay, but you showed up on the scene.
I showed up after the fact at the
Right,
station.
But you showed up on this, were you there on the scene when this allegedly occurred?
No.
Where it occurred?
No,
You saw the alleged victim where at the station?
at the station
Got it.
already.
Okay,
At which time, after the rock had already entered the vehicle compartment, Mr. White says that Mr. Filmore tried to grab for whatever he could before he left, fleeing.
when you say grabbed for whatever he could, what do you mean by
He's,
that?
I presume he just started grabbing around, see if he could take anything from within the vehicle.
Okay,
Now, this statement was corroborated by an individual who was parked right in front of Mr. White on the street, a witness.
did you get the name of that person?
Yes.
Is that Yanovac?
Yanovac.
Yanovac.
Yes, sir.
Okay, what did Yanovac, did you speak with Yanovac?
I've not spoken with Yanovac yet. I haven't been able to get a hold of him, but Deputy Batista, who is the original report writer, did speak to him.
Okay. And, okay. So, you want to continue, sir?
Your Honor, if I could just very briefly, Detective Toledo, when you took the witness's statement, when he said he was struck and the glass struck him, was he still sitting in the vehicle when that occurred?
Yes, he was all the time inside the vehicle.
Okay, thank you. Please continue.
After that incident, Mr. Filmore met up with a second individual who hasn't been charged yet, but it's believed that Mr. Filmore was going to trade drugs for a gun. They were spooked by the police as they were looking for Mr. Filmore. The second individual dropped the gun, and Mr. Filmore picked it up and started running.
Well, let me ask you this, how do you know that? How do you know that Mr. Filmore picked up a gun?
We know from several witnesses at the park that saw Mr. Filmore running with a gun, and Sergeant Anderson actually observed Mr. Filmore with a gun running as they were chasing him.
Okay, how long after this incident at the vehicle with the smashing of the window was it that somebody saw Mr. Filmore with a gun?
Judge, at this time I'm objecting to this line of questioning. It seems that this is a second incident that is not related to the issue at hand before the court, and we're still at the PC phase.
This relates to, he's also been charged with possession of a firearm or weapon
Right.
by a
Yes.
convicted felon.
Right.
Yes.
So that's what I'm trying to get at, figure out if you really had this weapon. So keep going. Now let me ask you this. So what was the time frame between the rock hitting the window and someone seeing him with the gun?
Approximately 20 minutes or so.
20 minutes, okay. All right, and let me just back up. Did anybody see him with a gun or a firearm at the time he smashed the window?
No.
Okay. The person in the car felt that he may have a gun because he reached behind his back, but nobody saw a gun.
Correct.
So 20 minutes later, some people in a park, do you have their names?
I believe Deputy Batista still has those names.
Okay. They saw him pick up a gun And the gun was dropped by some other local person?
Yes, sir.
Okay. All right. And go ahead, sir.
So after they chased Mr. Filmore, that same gun was located right in the vicinity of where Mr. Filmore was, underneath a shed.
Okay. How do you know it was the same gun?
We're supposing it's the same gun. It was just similar to what he was carrying, according to Sergeant Anderson, who actually saw the gun in his hand as he was running.
Sergeant Anderson saw the gun in his hand as he was running?
Yes, sir.
From the time, if you know, from the time Sergeant Anderson saw him with the gun to the time the defendant was apprehended, do you know how long that time was?
It was approximately a minute to 2 minutes away.
Okay. And were you there, or did you go to the location where the defendant was apprehended?
No, I maintained my status at the station after the fact.
I understand. I'm just trying to clarify the issues, that's all.
No.
What I'm trying to figure out is where he was apprehended, from where he was apprehended to where this handgun was located. I mean, is it a closed area? How far away would it have been?
I'm not able to answer any of those right now.
Okay, were you able to pull any prints off the gun?
We have DNA from the weapon and DNA from Mr. Filmore, who volunteered DNA, and we sent that to the lab already.
But to back up, one of your detectives saw this defendant running with a handgun.
Yes.
Okay, and he was apprehended, and when he was apprehended, they found a handgun within a close proximity of him.
Yes, Your Honor.
And it was similar, that you're saying that this detective said it was similar to the handgun he saw him running away?
Yes, Your Honor.
Okay. All right. Do you know whether or not this defendant knew the man in the car? Did they know each other?
Not the individual in the vehicle, no.
Okay. Was the window of the vehicle... Here's something I want to find out. At one point... He was on the Here's what I need to find out here. It says while White's vehicle was stopped, he was on the telephone. I'm reading from the report, the supplemental report, third paragraph down. While White's vehicle, do you see that?
Yes, sir.
He was on the telephone. He hears this defendant say a racial comment to him. Give me all your SH cracker. Now, was the window up or was the window down?
The window was partially down, not completely down.
Okay. All right. And Mr. White was he able to identify this?
Yes, a show-up was conducted after he was apprehended, and from what I'm told, he positively ID'd him right away, no hesitation.
Was there, did you look at the vehicle, Mr. White's vehicle?
It was not on scene when I arrived.
Okay. All right, I don't think, go ahead, Steve.
Well, Your Honor, if I may, and if the court wishes to take judicial notice, I checked on Google Maps the distance between where the gun was allegedly found at 111 Northwest 8th Avenue and where he was, according to the report, arrested at 111 Northwest 6th Avenue. Okay. And it's showing that the distance is approximately 1/10 of a mile.
Okay. All right. Anything else, Dave?
Detective, did you have an opportunity to ask Mr. White when, at the moment where Mr. Filmore was allegedly striking the window with the rock in his hand, was Mr. White in fear?
Yes, he was.
And at that time, did he have an opportunity to observe that Mr. Filmore had something in his hand?
Yes.
Okay. No further questions, Your Honor.
Okay. Mr. Miller, I'll give you a couple questions. I'll let the defense, this is a very serious case, I'll let them ask a couple questions. Go ahead.
I'll be nice, Judge. Real quick, how do you know he was in fear?
He told me so in the statement.
Okay. Now, you said that you assumed that he reached in and grabbed a whole bunch of property. Where are you getting that assumption from?
No, I did not assume. I said that he reached in and started grabbing as per the victim's statement.
Okay, I wrote down that you said, I assume he reached in and started grabbing stuff.
You must have misheard. We'll keep going.
I'm sorry, you said we'll keep going?
Sure, go ahead. Next question.
Okay. The second incident, the alleged handgun, how far away was the police officer when he said he saw the handgun in my client's hand stand up straight?
I was not on scene. I really couldn't tell you. All I got is from the report where he actually saw him running with the handgun.
Okay, so something that looked like a handgun. You can't be sure it was a handgun, correct?
He told me it was a handgun. I would assume that he knows what a handgun would look like. I'm going on his testimony to me.
Okay, but you don't know.
I was not there.
Okay. No one ever saw him. No, but when he was apprehended, he did not have a handgun in his possession. Is that correct?
Not on him at the time, no.
Okay. Now, earlier you testified that the victim, the alleged victim in this case, opened the door into Mr. Filmore. Is that correct?
Yes.
And that's when he broke the window with his rock. Is that correct?
It was a simultaneous action between the two.
Okay, so the door was actually open when the window was broken. Is that correct?
Correct.
Please stop.
And I threw the rock and ran.
Okay, I'm done.
Sorry,
Thank you.
sir. Please, I'm sorry.
So I think for the record, you just said I threw a rock.
No, that's not what he said, Judge. He said he tried to hit me with the door.
Yeah, I'm losing. Can I tell the
Stop for a
judge something?
second. We're going to take about a 2-minute break. I'll be right back. State, are you seeking a foreclosed bond and release conditions on count 2?
Yes, Your Honor.
Today, the court will find...
Judge, I'm
Go
sorry,
ahead,
may I
sir.
make my argument?
Yes, sir, go ahead.
Just briefly, on count 2, it appears that that door was open when the alleged battery occurred. He was not inside the car when it happened. I would argue that that's not a burglary. It's criminal mischief. I would have to stop. Judge, there's no proof evident, presumption great. Remember, we got that high standard to reach here, and with that door being open when that window was allegedly smashed, you've got a question of fact whether or not this was actually a burglary. And so I'm asking the court to find no proof evident, presumption great, and give him an appropriate bond in this case.
Okay. Well, the court finds whether the door was in the process of being opened or whether the door was completely closed. The court's understanding of the facts in this case was the defendant was in contemporaneously attempting to smash the window of that door, and in any event, whether the door was completely open or completely shut, the defendant, in this court's opinion of reviewing these facts, broke the plane of where that door frame was, whether it was a closed door or an open door, and went into the vehicle with the rock, glass particles hitting the defendant or hitting the alleged victim in the face, the rock hitting the alleged victim's hand. The court believes that that is the battery, that is the burglary, and the court will...
Judge, I'm sorry, can I throw out a hypothetical real quick?
I'm sorry?
Briefly, sir, briefly.
Okay, so standing at the front door of your house, you open the door, okay, outside of the house. I didn't enter the plane. Everything happens on the threshold there, outside of the house. Are you still going to have a burglary, or is there something else going on here? Do you have proof evident, presumption great, or is there something that still has to be decided by a finder of fact?
No, in this case, the court believes that this alleged victim was still in his vehicle, and no matter where the door was, this defendant allegedly caused a rock and glass to enter the compartment of that vehicle and strike the alleged victim. And the court also notes that these acts were preceded immediately by a racial comment, which I assume, did you meet the alleged victim?
Yes, sir.
What ethnic group would he be a member of? A white man?
White male.
White male. So he's a white male, and this defendant allegedly, just prior to this crime, referred to him as a cracker. So that gives the court the court believes that there was the intent to cause harm to him at this stage by his own words. The court also notes that his own words today put him at the scene of the crime. He allegedly said he opened the door and I hit the window with a rock. So the defendant's own words in court here put him at the scene of the crime with a rock in his hand and smashing the window. After that, we can rely on the testimony of the alleged victim. So count 2, proof evident, presumption great, defendant will be held without bond pursuant to the Preston case and the Keel case. This court believes it has no discretion to set a bond today, and that the defendant's only manner of relief is to have an Arthur hearing in the trial court. Now, State, is he a convicted felon?
He's an adjudicated delinquent if the court would like to go sidebar. You know what, and for the bond that the court's going to have to set on count 1, the court should probably be aware of his juvenile record also.
You want to go to the telephone and we'll tell you what the juvenile record is, Mr. Miller? Okay. Okay. Court will consider his juvenile record. Count 3 and 4, the court's going to find probable cause. Count 1 is an attempted robbery. Now, State, do you have any? Let me ask defense, sir. You want to state any? You have any comments before the court sets bond on count 1, 3, and 4?
Judge, no, I do not. If you want to ask, that's fine with me.
Sir, do you have any money in the bank, Mr. Filmore?
Yes, sir. If I have a bond, I have my family come up with something to get me out.
How much money do you have in the bank?
Probably like $1,000.
Do you own any land or property here in South Florida?
No, sir.
Okay. Sir, I'm going to, based on your serious juvenile record, the facts, alleged facts of this case, that you not only tried to attack a man or attacked a man and his vehicle, referred to him in a racial manner, then allegedly ran away, picked up a handgun, witnesses saw you with a handgun, and taken into consideration your very serious juvenile record, the court believes you represent a danger to the community. The court also notes that you with your juvenile record, you shouldn't have a handgun in your possession. And the court notes the strength of the case. There's several witnesses who saw you during the course of these criminal acts. We have the man in the vehicle who claims you took the rock, the glass went in, he got hit, the detective saw the cut on his head. Then you in court today put yourself at the scene of the crime by your own words. You said you had a rock, you said you smashed a window. Now I know you have a different version of it, but you put yourself at the scene of the crime. The court believes you do represent a danger to the community. The court notes the strength of the case against you. Count 1, like I say, based on your juvenile record, the facts of the case, $50,000 on 1. Count 3 and 4, those will be $10,000 per count. And count 2, the burglary, you're going to be held without bond. The court will order. You have no contact with Thomas White directly and indirectly. Thank you. Thank you.
Thank you, Your Honor.
Now.